Good morning. I'm John Burns, and I'm pleased that you have joined us today for Community Connection for March 2021. Our topic today are Advance Care Directives and why you need them. I'm pleased that you have joined us. As I mentioned, I'm John Burns, and I'm a board-certified elder law attorney practicing in Decatur, Alabama. My firm, John Burns Estate and Elder Care Law, serves clients throughout northern Alabama and southern Middle Tennessee. We're a life care planning law firm, which means that in addition to myself performing normal legal functions, we also have on staff a full-time licensed social worker who is our elder care coordinator, as well as a public benefits specialist who assists with qualification for Medicaid, SSI, disability, and VA benefits. So one of the topics that I frequently meet with clients about is estate planning, and particularly one of the important topics there has to do with Advanced Care Directives. And many clients will invariably say to me, all that's just fine, but we have that in place already. Or alternatively, not to worry, I have a DNR, isn't that good enough? And what I have to explain to them is, it's probably not. You see, a DNR is a do not resuscitate order, and it applies only to emergency treatments. Effectively, what it says is that if my heart or my lungs stop working, that I do not wish to be artificially resuscitated. They typically come in two types. There's the in-hospital DNR, which is signed by the physician and is part of the patient's record. And then there's an in-home DNR that the patient and his or her physician may have completed at some time to cover clients that are either living at home or living in a long-term care facility. But the important thing to keep in mind is this, that a DNR, while it will authorize the suspension or discontinuance of artificial resuscitation, it does not authorize the discontinuance or withholding of any other medical care. And that is where the healthcare power of attorney, the living will, or when we put them together, the Advance Care Directive come into play. Now, historically, we have had living wills and healthcare powers of attorney for many, many years, even decades. And by those documents, particularly the living will, someone can state what his or her wishes are regarding end-of-life decisions, particularly in two principal contexts that most states have recognized. And that is that if they are terminally ill or injured, in which there's no medical probability of recovery, or they're permanently unconscious, in which there is no medical probability of coming out of unconsciousness, then individuals are typically called upon to make one of two decisions, and maybe even both. And the first is, do they wish to continue to have artificial life-sustaining treatment? This is not life-saving treatment, as I explain to clients. This is simply life-sustaining treatment that could keep you alive indefinitely, despite the fact that your body, if left to its own mechanisms, would perish. The second is, does the client wish to have artificially provided food and nourishment? And so those are the questions that are typically asked that states may need to see the answer if some question of the termination of life support ever becomes contentious and ever leads to litigation. And while those are rare instances, when they arise, they typically garner a great deal of attention, a lot of media coverage, and quite frankly, a lot of expense that we can avoid if we have good, comprehensive life care directives. So, now, I want to tell you that advance directives are not, pardon the pun, a cure-all. There are some issues with those. First of all, most people do not complete them, and that's just the reality. In many instances, the forms themselves are hard to understand, and the forms offer very little guidance. The reality is that people change their mind. Age, maturity, and life events often cause people to make different decisions at different points in their lives. But perhaps the two biggest issues that I see, and the two biggest shortcomings with advanced care directives that I see on a regular basis, are the fact that the agent, the person who has been appointed to make healthcare decisions, is completely unaware of their office and their duties and responsibility. And secondly, many healthcare providers themselves are often unaware that there is a valid Advance Care Directive. So it's important that if you sign one, that you have that full and frank discussion with your agent regarding your decisions and your wishes so that person knows what you want to happen. And secondly, it's important that your doctor and other medical providers be provided with those documents as needed. Ideally, in your chart, the charts occasionally get lost. The reality is having that information readily available is absolutely paramount. Now, Advance Care Directives can do a lot of things, and they also cannot do some things. One thing to keep in mind is this. Advance Care Directives are not a cookbook for end-of-life care. Advance Care Directives can give general sentiments about wanting or not wanting life support if it only prolongs the dying process or if treatment would otherwise be heroic or extraordinary. An Advance Care Directive simply cannot change the fact that dying is emotional and it is complicated. It cannot eliminate personal ambivalence. But most importantly, it cannot be a substitute for frank discussion with friends and family about what someone wants to happen in that event. Now, Advance Care Directives do have a number of benefits, and that is why I recommend them. Number one, they can support a process of advanced care planning, and we see that at our firm as a major task and responsibility. Secondly, it can empower and educate a healthcare agent about his or her responsibilities and the preferences of the patient. It requires folks to stop, to think and discuss their goals, their priorities, and their values. Now, as part of our process, we take a comprehensive, if you want to say a holistic approach toward elder care. And we believe that advanced planning of any type, whether it's for healthcare decisions that we're talking about today, or for asset protection and general estate planning, is a process. The important thing to keep in mind is Advance Care Directives are only worth the discussions that they're based on. And if there are no discussions underlying that and no notification to the agents of what their responsibilities or the preferences of the patient would be, then those Advance Care Directives are quite frankly not worth the paper they're written on. But it does require one to understand and appreciate the client's perceptions and concerns. And many times when we're discussing Advance Care Directives with clients, I do have to explain to them, these are not life-saving measures. These are simply life-sustaining measures. There's a concept called implied consent that accompanies life-saving measures. And maybe that's where that DNR comes into play. But this is once there's been some stabilization and we're trying to make decisions, or we're trying to forecast what decisions could be regarding life-sustaining treatment. And that's where the role of the lawyer and the healthcare provider really come into play in taking this holistic approach. The other thing to keep in mind about healthcare directives of any type is they only take effect if the patient is either unable or incapable of making a decision for himself or herself, or is incapable of communicating that decision to others. The point being that so long as you have capacity to make the decision, you get to make it. And so long as you can convey that decision and communicate it, then you should do it. The Advance Care Directive only comes into play where you cannot make the decision and or you cannot communicate that decision. So the important thing also to keep in mind is this. This is not an issue that affects only our senior or elderly clients. The reality is this. Most of the famous cases, Karen Ann Quinlan, for those of you who remember back in the 70s and early 80s, Nancy Cruzan from the early 90s, and more recently, even though it's been about 20 years ago, as I was recently reminded, Terry Schiavo out of Florida. were all cases that involved relatively young women. So it is not an old folks issue, and that is what is important to keep in mind. And I tell folks who execute their advanced care directives that they should always be aware of the 5Ds. In other words, people ask me, how often should I review my documents? And how often should I update them? And I'll usually tell them as needed. But the reality is, anytime you enter a new decade, or anytime there has been a death of a family member or friend, particularly someone you're relying upon perhaps in some of these documents, if there's been a divorce, if there's been some significant diagnosis such as dementia, or if there has been some significant decline in one's condition, you should carefully look at the Advance Care Directives and, frankly, all of your estate planning documents, including your durable power of attorney, as well as wills, trust agreements, and the like, to determine if those still reflect and convey what your wishes are. Also, I will tell you that if there is another D, meaning the change of domicile, meaning that you move from one state to another, you also need to consider updating your documents, in particular your Advance Care Directives. So let's look at some of the issues that we arise in regard to drafting these documents. The first issue we see is selecting the appropriate agent. It's much like selecting a doctor. You probably want to pick somebody who's younger than you are. Now, invariably, and the natural choice is to pick one's spouse. And I would say at least 75% or more of mine, appoint the spouse. And that's normal and it is to be expected. But in addition to appointing the spouse, think about appointing someone whose both age and capacity would indicate that they would survive you or your incapacity. And that's not always the case with a spouse. But the other important thing is this: regardless of who you appoint, whether it's a spouse, a child, somebody else, make sure that you have an assertive advocate who understands your values and wishes and will insist on knowing all of the medical facts and their implications for health and the quality of your life, so that they can then apply those facts along with your wishes to make an accurate and informed decision. In other words, what can we do to help your agent make the decision that you would have made if you were capable of making it? Now, the other thing is this: consider the scope of the agent's authority. And we try to be relatively broad, but also we have to be specific. Now, some colleagues of mine will draft it very broadly, and I certainly see those, and those are just fine. Others will limit it drastically. I always have to caution in those cases, be careful that you don't limit it too much. But it is important to be explicit about the agent's breadth of authority, especially with respect to in respect to decisions to withhold life-sustaining treatment and procedures. Because the question is always going to be, how much authority is enough? How much is too much? So, the other thing is this: consider any ancillary powers that you want to give to your agent. Now, this could be everything from consent to experimental powers, as well as an extension of certain powers to post-mortem situations, such as anatomical gifts, autopsies, disposition of the remains, and the like, as well as the ability to institute legal proceedings if need be. You may also want to consider their authority to seek additional insurance coverage for you, to change your domicile, and the ability to delegate authority if need be. The other issue we see, and we don't see it so much in the Advance Care Directive context, but we do see it occasionally, is whether to make the power immediate or springing. The reality is this, and as I mentioned earlier, so long as you can make and communicate the decision, you get to make the decision, despite what any other document you have said or signed may provide. And as long as you have capacity, you can always revoke that document. But nonetheless, it is important to understand that In all likelihood, when you sign an Advance Care Directive or a healthcare power of attorney, it will usually be effective immediately. And practically speaking, I generally find that to be the best course of action, because having what we call a springing power of attorney, one that is signed and executed properly but lays dormant for some period of time until you're deemed incapacitated, and then the agent can make the decision, frankly, is time consuming, expensive, and burdensome, and wastes a lot of valuable time and money when it comes time to make an urgent decision. I vividly remember having to run through, and frankly spending the better part of a day running back and forth from my office to a major hospital in a city where I used to practice in order to get the two physicians' signatures that I needed to declare a patient incompetent, or I should say incapacitated, in order to trigger the validity of a power of attorney. My advice is avoid that when at all possible. So those are some of the tips and insights we have in regard to powers of attorney. Most states have statutory powers of attorney that you can normally find on that state's Department of Health's website. They are good, they are valid. You may want to modify them. You may work with a lawyer, such as myself or someone else, who may have similar forms that may be broader or more specific, or even in some cases more general, depending on the client's capacity. In Alabama, for example, we have a statutory form that requires the client to make a variety of affirmative elections in regard to care and treatment that he or she is seeking or not seeking in the event of terminal illness or injury or permanent unconsciousness. In addition, it gets to be confusing, as I mentioned earlier, because you can actually undo those after you appoint a healthcare agent and give them complete discretion to override anything you previously have said. Also, an Advance Care Directive will give you the ability to make any other wishes or statements. We typically see these fall into a couple of categories. One is religious. You may wish to have last rites, or rabbinical decisor, or particular treatment or consultation immediately prior to death or the termination of life-sustaining support. Also, we find them falling into a general category where folks simply can make their own written affirmations or statements regarding that they wish to be kept comfortable and as pain-free as is possible. But nonetheless, the Advance Care Directive is a vital document that we recommend that all of our clients have. If nothing else, it provides guidance and direction, even in the most general terms, to an agent who is often called upon to make a decision at a time of great stress, often at a time of crisis, and certainly at a time in which emotions are riding high. And so this is a guidebook that at least can help them navigate those treacherous times. So thank you very much for your attendance today. Next month, we will have another community connection, and I hope you all will join us then. Thank you.